Good morning. This is Heidi Meyers, Immigration and Economic Sanctions Attorney. Today we're going to talk about a new federal court decision issued December 1st, 2020 in the Northern District of California. This decision stops the Department of Labor from issuing its new prevailing wage rule, and it also stops Department of Homeland Security from issuing its new rule regarding H-1B foreign temporary workers and changing the definition of specialty occupation. So first, we're going to talk about prevailing wages. Department of Labor has had a system for determining prevailing wages for many years. Now, an American employer, before they can hire a foreign professional, must get a prevailing wage from the Department of Labor. So for both the H-1B petition, the H-1B is for temporary foreign professionals in specialty occupations, or also for the perm labor certification if the employer wants to sponsor a foreign national for the green card through employment for a professional or advanced degree worker, then they first have to get a prevailing wage from the Department of Labor. So the Department of Labor's prevailing wage system looks at, number one, what is the occupation? So they have certain occupational definitions, and they also look at the geographic location. So the geographic location is limited to, say, a metropolitan statistical area or an area within normal commuting distance, such as New York City. So they look at the occupation, they look at the specific geographic location, and they look at the level of education, experience, and knowledge that the position requires. So the Department of Labor already had a system where there were 4 levels of prevailing wages. So level 1 was for entry-level or beginning workers who are very closely supervised. And that was those wages were with up to the 17th percentile of workers. The second, so they had level 2, which was more experienced. Level 3, level 3 tends to have supervisory or perhaps some managerial workers. And then level 4 is your most experienced management level people. So the initial, prior to the new rule, Department of Labor already had a very sophisticated system for determining prevailing wages. And these wages were revised generally every July. So each year, Department of Labor would generally revise all the prevailing wages upward, but staying within these same percentiles. So the percentiles, as I said before, were initially level 1, 17%, level 2, 34%, and then let's see here, where's our percentages? Level 3, 50th percent, and level 4, 67th percent. So what Department of Labor did was they revised those percentages way upward. So a level 1 entry-level job was no longer at the 17th percentile. It was at the 45th percentile, which is almost in the middle. So rather than paying an entry-level worker an entry-level wage, employers would have had to have paid them a wage really meant for a much more experienced individual. And so the wages were revised way upward, and the level 4 was revised up to the 95th percentile. So what ended up happening was that the wages were revised so far up that $208,000 per year became the salary for many occupations in many locations. So it was the salaries were revised so far upward that, say, for an entry-level computer position, IT position in Silicon Valley, you would have a wage of $208,000 per year. And actually, for many occupations in many locations, this ended up being the default wage, no matter how little experience the individual had or how much they had. So, of course, employers were very upset about it, and it meant that if it was to continue, that employers would not be able to fill these positions because these are positions for which there are not enough U.S. workers. Positions in IT, in STEM, science, technology, engineering, and math, a lot of university level positions. Universities would not have been able to fill their positions because they couldn't afford to pay those unbelievable high wages. So the court said that the government's justification for doing away with the notice and comment period before issuing the rule did not meet the good cause exception to the APA, the Administrative Procedures Act. So basically, the court found there was no real emergency or urgency in issuing this new wage rule. And it found the same thing with the new H-1B rule as well. So basically, the Trump administration issued the Buy American, Hire American, BAHA executive order way back in 2017 and already had this idea in mind prior to the COVID pandemic. So the COVID pandemic was not actually the real justification for the new rule because they had already had this rule in mind for several years. And similarly, the new H-1B rule, which would have restricted the definition of H-1B specialty occupation so much that by the government's own estimate, it would eliminate about 1/3 of all H-1B jobs. Petitions, I'm sorry. So the new H-1B rule would have restricted the definition of specialty occupation where you would have to show that that occupation requires one specific degree. So for example, a mechanical engineering position would require a mechanical engineering degree. Well, that makes sense. But there are a lot of professional, highly technical occupations where, say, more than one degree might be suitable for the job. So for example, with a systems analyst or a business analyst, the person might have an IT degree in various fields, or they might have an MBA with a specialty in IT. So a lot of very advanced positions, you could have some sort of combination of degrees, or you can't really show that only one specific degree in particular qualifies you to do the job. So it would have eliminated a lot of H-1B petitions. And then the other aspect, which was directed against the IT industry, was with the IT industry, the work model is that you send your IT guy out to your client site, to the third-party client site, and so it would have restricted those types of petition validity dates from 3 years to 1 year. The employer would have to show they have work the entire time for the individual. Just a lot of very unreasonable requirements, which was basically a reaction to prior litigation against certain policies. So anyway, the court found that, again, there was no good cause exception to the notice and comment requirement of the APA, the Administrative Procedures Act, and stopped the Department of Homeland Security from issuing this new rule. So one thing we need to clarify is that it does not stop the government. It does not stop Department of Labor. It does not stop Department of Homeland Security from issuing new regulations. It stops them from issuing them without following the notice and comment procedures, which is when a federal agency decides to issue a new rule, they're supposed to issue a proposed rule, and then give interested parties, employers, the public, time to comment on the rule. So the federal agency gets feedback, and then when it's finalizing the rule, it has to respond to those comments and explain its justification for each provision in the final rule and why maybe they're going along with what some of the comments said, or if they decide to go against what certain comments from employers and the public say, they're explaining their reasoning. And it's, responds, it holds the agency accountable, it's more democratic. So basically, Department of Homeland Security and Department of Labor are not prohibited from issuing new rules. They can go ahead and issue a new regulation, but they have to follow the comment and notice procedures. They have to give employers, workers, organizations, the public, time to read the new proposed rule, come up with their own point of view, their own comments, and for the federal agency to be responsive to the public and to have a reasoned, justified, reasonable explanation for why they're doing what they're doing. So that's about it for today. Basically, I think I didn't mention the unemployment figures. So the court also found that the government's general reliance on general unemployment, that generally there's more unemployment since COVID-19, that this was not a valid justification for dispensing with notice and comment because H-1B workers are not the general population. The most H-1B petitions are for IT professionals and other professional and other types of professional and business services. People who have very advanced degrees, people who are very well educated, who are very skilled. Like I said, we mentioned the STEM, science, technology, engineering, and math. And in fact, the Bureau of Labor Statistics, which is part of Department of Labor, in October 2020 found that there was actually growth in demand for professional and business services, and that the unemployment rate for individuals with a bachelor's or higher degree was actually only 4.8% or so. So looking at the general unemployment rate of the population is not a valid comparison, because you're not talking about waiters in a restaurant, you're not talking about low-level service workers, you're talking about highly educated, skilled workers, many of whom are primarily in IT and other advanced science, technology, engineering, and math fields. All right, so that's about it for today. This is Heidi Meyers, Immigration and Economic Sanctions Attorney. I'm at 11 Broadway, Suite 925, New York, New York, 10004. My number is 212-791-4007 or 646-508-5225. And my email is heidimeyerslaw@gmail.com. All right, thank you very much. And if you have any ideas for video topics, please let me know. All right, so everybody have a good day. Bye-bye.